she's in foreclosure, which is one of the bigger ones. Seems, my wife keeps telling me that we've been down for 5 years.
No, just as long as it's,
I went through it.
the table wasn't now, that's no reason.
Go through that, I think Tarpon Springs. Really good.
Radio Falls.
Yeah. Oldsmar started that about
tear.
10, 15 years ago, and then everybody seems to be following in line.
That's like the new thing. Is that one of those rubber
Really gives you
bands?
a chance.
Yeah.
The silicone one.
Yeah,
I mean, at the fire
they're
station.
nice because I don't have to
Go
wear
to
that
water
whole-
treatment.
Where'd you get it?
Water.
Qualo. Qualo.
Online?
$19.99. My wife bought me like 6 of them.
This wedding.
Yeah, it's a nice alternative.
This one's got the thin blue line
Go
on
to
it.
this conference.
They make the fire one, the red.
Chip shake.
Have a camouflage one, green one, black one.
For all occasions?
For all occasions.
For all occasions.
I can't wear them.
Camouflage.
Crazy.
Is that when you're hiding from the wife? With a
I
camouflage?
still have the I still have the chin. So,
Applications.
but I don't, when I work out, I don't have to take it off. Won't get caught on the fence and tear my.
A lot of the small beach communities don't.
Well, like fishing probably one of those type of bands instead of a regular band. You know how they're always touching metal. Good idea.
Got a lot of my grandfathers here.
Jerry went to a baseball game. No, that's like right
That's
after
the way it
mine.
was.
I was
when
gonna
started
say,
here in 1930 and
but it looks like the sweet hand is moving. It's just not
Was
right.
you coming to work early?
For the ring. I remember I left it home.
Oh, maybe one like this and it flew off.
Yeah.
Hey, I'm not gonna comment on that.
Never mind.
I used to wear it
Tarpon
just,
Springs since 1973, and
that's funny, my husband worked
I
with
don't
his
work
hand and he's like,
anymore, but I was living there since
he doesn't wear
73
it
until I got married.
anymore really at all because his fingers got taken off. But it was funny.
You know better than I
because he used to try to calm
I don't have
down.
to tell you
And it's like,
anything.
put it away. It's okay because I'd rather see your finger ripped off because he, like I
Wonder
said,
how we doing on
electrocuted.
St.
Or
Louis
like,
dogs.
Oh, good.
All right. That's a nice cause that you work for.
It's the best job I've ever done. I love
Yeah.
it.
It's good. It must really, especially when you see that a dog goes to a family that loves it. It's like
Yeah.
both sides win. The dog wins and the family wins.
Right. We get so many abused animals, and it's just amazing that they can forgive.
I see
Bedded
pictures on
collars.
I see pictures on the internet of they'll say this what the dog looked like when
Right.
they picked them up.
what you doing here
Here's what it
today?
is
They
now.
got
It's
you
like-
testifying.
Yeah. I've had dogs.
There you go.
Guy cut this dog's tail off.
I think I heard that.
He had like 13 stitches in his arm, and when he came into the vet, she did like 5 surgeries. She said she didn't even know there was a hole that side. She could see his spine, and he's just the greatest dog in the world.
There's a big
All
one
they
on
can
here,
forgive.
right?
Well,
Amazing.
I had
Which
my
one?
grandfather came from Greece.
Oh, never
He
mind.
used to say he loved
That line
dogs,
is something
and he didn't
else.
like cats. He said the difference between
Great when
a
it works
dog
and terrible
is
when
got
it
a cat
doesn't.
for 10 years. If it's hungry, somebody walks by with a can of tuna fish, your cat's gone. If you have a dog, you're starving to death. The dog will starve with you.
Yeah.
The dog
Yeah.
won't desert you. He'll stay with you.
My dog got diagnosed with cancer last July, and I didn't think he'd see Christmas. But I've been everything that says it fights cancer, I give him. And because the tumor appeared like in 3 weeks.
And I got this
went
sun
from
done.
nothing to tennis ball. And I just thought as fast
Power
as
source is the sun.
and they couldn't
That's
cut
nice.
it all out
Yeah.
if it was around
We were talking about watching the other day how
If they cut it all out, he had no muscle.
one of the girls I work with,
So
her
he's been
father
taking all
has
kinds
the same watch, the
pills
wind
and
up one.
vitamins.
He's changed bands
And
100
he doesn't
times,
even
but
look sick.
it shows you
Knock on wood.
time after
And
you make a
the
good
tumor
watch.
hasn't come back out yet. So
You just gotta remember.
The sad responsibility all dog owners have, though, is sometimes you got to put
Yeah,
it down.
yeah,
When
and-
the time is right. That's a responsibility that goes with the owner.
And I saw so many. I see so many of our dogs with cancer, and if somebody takes them for the surgery and then follows through with radiation or chemo, they still die, but they're really sick. And I wouldn't go for that. I would never never been sick, and I'm healthy as well.
Went on a cruise, you said.
Good thing.
Let's call her up.
We're here 2 o'clock, and just one other thing, if, you know, if there's, if you become chair, that's the only reason that we need to fight here again.
Mm-hmm.
If someone else becomes chair, you only need that one, because you are vice chair.
Okay. Just looking off. I may not. Who knows?
I'm just,
All right, find my agenda. I guess we're ready. I wait for him or do
That's
I bang
fine.
the gavel? Okay. Ladies and gentlemen, the time is 2 o'clock p.m. and I'd like to call the Code of Enforcement Board into session. Mr. Trask, if you would please lead us in the invocation. And if you have a cell phone, if you either turn it down or turn it to silence, please, I appreciate it. Thank you.
Our Heavenly Father, we seek blessings on the tasks before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We pray that our work this afternoon will find favor in your sight. Amen.
Amen. And now for the Pledge of Allegiance, please. Well, the flag is back there, we know, but it's hidden by a curtain.
I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I'd like to ask the clerk, can we have a roll call, please?
Mr. Demasis,
Here.
Ms. Casey,
Here.
Mrs. Archer,
Here.
Mr. Charrier,
Here.
Mr. Bergerman,
Here.
Mrs. Dabbs.
Here.
That completes your roll call.
let's go through the hearing procedures,
All right.
and then the swearing in, and then we're, okay.
I'd like to explain the hearing procedures that'll be in effect today, just as always with the Code Enforcement Board. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure of the board is as follows. First, the city presents its witnesses and exhibits, after which the alleged violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the alleged violator is allowed to make a presentation and present his or her witnesses and exhibits. Then the city can question the alleged violator's witnesses. After both rounds of testimony, both on the part of the city and on the part of the alleged violator, each party is asked to give a closing argument, first by the city and then by the alleged violator. After those three steps are taken, this board will close the public hearing portion of the case to discuss it and take appropriate action. Before we begin the public hearings, we will have all potential witnesses stand up and be sworn by the secretary of the board. If you feel that you're going to give testimony today, if you'd please rise.
Raise your right hand. Thank you. Do you swear the testimony you're about to give is the whole truth and nothing but the truth?
I do.
Thank you. You be seated.
Okay, before we go any further, the board has a bit of business that we need to take care of, and that is we have received the resignation of the chairman, and today as vice chairman, I'd like to call for the nominations and a vote to fill that vacant chairman's positions. Can we have any nominations, please?
For the chairman, I'll nominate you.
Thank you, Wanda.
A second.
Any other nominations? Okay, I guess we'll take a vote then. A roll call vote, please.
Yes, sir. Ms. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Mr. Charrier?
Yes.
Mrs. Archer?
Yes.
Ms. Vaquesi?
Yes.
Mr. DeMasis?
Well, modesty aside, I'll vote for myself. And I thank my fellow board members.
It's a landslide.
It's the only thing I've ever won. Thank you very much. We'll also have to make a vote for a vice chairman. Do we have any nominations for vice chairman?
I would like to nominate Becky Archer.
I'll second that. Anybody else that wants to put their name forward? Well, then let's have a vote on Mrs. Archer. If I would ask the secretary for a roll call, please.
Yes, sir. Mrs. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Mr. Charrier?
Yes.
Mrs. Archer?
I guess so.
I guess so. We need a yes or a no. We'll take that as a yes.
Ms. Vaquesi?
Yes.
And Mr. DeMasis?
Yes.
Should we trade places, Becky and I now?
No.
Yeah,
No.
you're it for today, kid. All right.
Alrighty, down and down.
Okay, those items having been taken care of, we'll now move to the public hearings, new business. The first case that we have is case number 17-800000002, 106 East Lime Street. Is there anyone here to respond to 106 East Lime Street? And if you, are you here for 106 East Lime Street?
Bonnie.
She's a secretary.
Oh, all right.
Give us the copies of the.
I'm sorry. I
You remember
okay.
Sue? Bonnie is always in the background.
Yeah.
Bonnie, all right.
Party's on a cruise.
I take it you're not here for
we get a
106 East Lime Street. Now, does anybody want to have a re-vote on who should be chairman? All right. I mean, I'm willing. Okay. Okay, DeMatsis, first mistake. 2 minutes into being the chairman. All right. Bonnie, I apologize to you. And I apologize to anybody who is or isn't here from East Lime Street. But, okay, 106 East Lime Street, then I'll turn to the city's inspector, and if you would please introduce yourself, you can begin your testimony.
Thank you, Mr. Chairman. I'm Officer Steve Gasson, City of Tarpon Springs Police Department. I've been the code inspector with the city for 2 years. I've been a police officer with the City of Tarpon Springs now for 20 years. The case in question, 17-800000002, is 106 East Lime Street. The registered, or the listed owners are Paul and Tina Bacalapolo, probably pronounced incorrectly. The case I bring before you, the initial inspection of the property was January 3rd of this year. My initial observations with there's trash on property in the front and the rear. The structure's in very poor condition, debilitated. The yard needs to be mowed, trimmed, and edged. The trees need to be trimmed. Currently, the house is vacant. I've submitted pictures to the board. Exhibit number 1 are the photographs. There's 2 sets of photographs. One was the original, and then I took some just a couple of days ago on the final inspection. They're towards the back. At about that time, we sent the initial courtesy letter. All of the notices, including courtesy letters, notice of violation, and notice of hearing, are exhibit number 2 that's been submitted to the board. And all of my miscellaneous administrative documentation is exhibit number 3 that's been submitted to the board. Moving forward, I conducted a reinspection January 18th of this year, and there was no change at that point in time. I sent a notice of violation. Should be noted for the record that all my documentation as far as ownership was achieved via the Pinellas County Tax Collector, the Pinellas County Property Appraiser's website, and those notices were sent to those listed people and or addresses. On January 19th, the NOV, the notice of violation, was sent via first class certified mail. On January 26th, the green card addressed to the owner of record was signed, delivered on January 23rd. January 31st, had contact via email who originally requested an extension to take care of some of the issues with the property. I gave them until February 27th at 5 p.m. to clean up the property. On February 28th, I conducted a reinspection. Large amount of the trash had been cleaned up, but the structures are still in poor condition. The particular structures I'm talking about, if you saw the pictures, was there's 2 sheds in the backyard, and they kind of have a tilt. They look like a safety hazard. There's some minor issues with the actual house itself. Some of the siding's got issues. Some of the windows are broken. But it appears, and I'm not a building inspector or a structural engineer, that the building itself, the main part of the building seems to be intact. It just needs a little cleanup, even up until yesterday when I conducted the last inspection. But the 2 sheds in the back are an issue. As I stated, he cleaned up a lot of the property. Unfortunately, there's still some debris. You can see in the pictures, they kind of shoved it underneath the house. It looks like there's some couches and some other debris underneath the house. There's a couch over on the east side of the property. I would say it's about 85% done to be in compliance. The owner or the representative, when I talked to him, he had some issues with removing the shed or the building because of the parcel and the age of it and being able to rebuild a structure. I don't understand all that aspect of it, but we discussed especially those 2 sheds in the back being a safety issue and clearing those out before I'd put it into compliance. Moving forward again, I sent a notice of hearing on February 28th. That's included in the notices that came through. We returned back on March 3rd 2 certified green cards signed March 2nd by El Chia. The notice of hearing, first-class mailing was returned unopened. That was just the regular first-class, not certified. I posted the property on March 30th. That's exhibit number 4 that went around. And then on April 12th, I conducted a reinspection. Basically what I discussed. The 2 small buildings are still out back. There's still a little bit of trash. Most of the trees are taken care of. And those were the last couple of pictures that went through showing, like I said, a significant change, but still a couple of minor issues. As I stated, I've had no contact with the actual property owner, Joan. I'm sorry, I've had contact with Paul had contacted me, and he was the one I had a conversation with about, and he asked for the extension to clean up the property. He was the one who explained to me that couldn't move it. Like I said, I don't understand the parcel issues with that, but so at this point in time, the case before the board is a violation of City Code 822, which is the accumulation of trash. City Code 8-40, the duty to maintain private property, and the 852 nuisance prohibitions, which covers debris, block clearing, and those kind of things. And that, at this point, is all I have.
Does the board have any questions for the officer?
The house is vacant.
Yes, ma'am, it is.
Do you know where the owners live?
I can probably tell you. Give us a second.
I'm just-
Organized today.
I'm mostly interested if it's in
New person
Tarpon
that looks-
Springs or out of town.
I'd have to look at one of the notices which have already been submitted to evidence, so. Palm Harbor, I'm sorry.
Oh,
Palm Harbor.
okay. Thank you.
Any other questions? I have a question for you, officer.
Yes, sir.
Based on your conversation and based on the progression of what you've seen, do you, and I know you can't be a mind reader, but do you have a sense that they're working towards coming to a successful completion of what they need to do?
Yes, because the impression I believe he either flips houses or is in the business of building houses. So he's trying to do something with it, but there's some legal issues with the parcels and things like that. And like I said, he's gotten it mostly completed. I don't know the legality of those last 2. If he was to provide me some legal paperwork or something like that, which I could obviously present to the board, but about the 2 sheds not being able to be removed, I suppose they could be shored up to the point where they're safe, but that doesn't negate the issue. There's debris still on the property, which needs to be cleaned up.
Anybody have any further questions?
Officer Gossall,
Yes, sir.
question on it. Wasn't this house originally established a while ago?
Looking through my priors on this, the last one we had was in 13, and it doesn't show that it was established, and it had to deal with a different ordinance. And then we go back to 12 and 11, and at that point, we're greater than 5 years, so even if it was established back in 11, it wouldn't count to this day. So no.
Any further questions from the board? Officer, any closing statement?
No, just as I stated, I'd just like the board to find the violation of 822, 840, and 852, and that's all I have at this point.
All right. I imagine we're ready to take a vote. If there's no further discussion, can we get a motion first? Anybody like to make a motion?
I will. I move
you.
based on the testimony, evidence, and facts presented and law that at the time of the alleged violations, sections 8-2, 8-40, and 8-52 of the Code of Ordinances of the City of Tarpon Springs was in force and effect. Respondents were in violation thereof.
A second.
Second?
I just want to make clarity. I thought I heard 8-2. Did you mean to say 8-22?
Yes.
Okay. I just want to make sure that we got the right code section.
Do we have any, is there any need for discussion before we take a vote? Okay, apparently, we're ready. Can we have a roll call vote, please?
Mrs. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Mr. Charrier?
Yes.
Mrs. Archer?
Yes.
Ms. Vacacy?
Yes.
Mr. Demossis?
Yes.
The motion carries.
Okay, that brings us to our second case. It's case number 17.
Well, we're going to do the second portion of that motion first
Establish
Penalty.
a fine.
to establish the amount of. the
Oh,
fine
okay,
and
we're
so
gonna go
forth.
right, I'm sorry, we're gonna go right to that.
Okay. I'll go ahead then, if that's okay. I move that the respondent shall have until, the 8th day of May, 2017, to bring the property into compliance with code sections 8-22, 8-40, and 8-52, or suffer a fine of $50 per day for each day thereafter the respondents remain in violation of said code sections.
Second.
Okay, do we need to, any discussion? Are we ready to take a vote? Apparently, we're ready to take a vote. Can we get a roll call vote on the second motion?
Mrs. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Mr. Charrier?
Yes.
Mrs. Archer?
Yes.
Ms. Vacacy?
Yes.
Mr. Demossis?
Yes.
Motion carries, sir.
And that brings us now to our second case. It's case number 17-800000069. That's 1110 East Court Street. Anyone here for 1110 East Court Street? Okay. Sir, if you go over to the podium and give us your name and once we get that, we'll proceed.
Dan Deppies, and I'm here on behalf of the owner, which is the bank, and I brought a letter from the bank, just
Indicating that you're representing them today? Okay. Need to see that?
Yeah. Yep.
The other document is an estimate that I got on the damages, or the repairs.
Oh, this is the estimate. Does the bank own this property?
Yes,
The bank is the title holder?
yes.
We have it down as Ronald Wells and Lori Nova.
It was foreclosed. That should have, I want to say, first week in March, the bank took over.
Okay, well, it'd be best then, Mr. Gasson, that we do not proceed on this, because even if you've got your
We'd have to
order
open
in
a new case
place,
on it.
it would be unenforceable to consider it a wild lien.
That's fine.
So my suggestion is that it just be renoticed and brought back, and hopefully it's brought into compliance by then. Sir, we don't have the right party here cited, and so it's more important for us to get the right person. If the bank owns it now, the bank will probably be cited at this point. So you're going to remove it from the agenda then?
Yes,
That-
sir.
That's what we're going to do?
Yeah, we'll remove it from the agenda.
Okay.
All right, then, sir, we're finished for today, then.
Just a quick question. 2 months will that be okay?
What basically I have to happen is just open a new case for the same issues with the new owner.
Yeah.
So if you take care of it in 2 months, we probably won't be before this board again.
Cool.
So,
It'll be done.
Thank you.
Thank you, sir. All right, then, case number 2 that was just referred to is going to be considered as being withdrawn. That moves us on to the next case, case number 17-800000072, 705 South Diston Street, Diston. Is there anyone here for that piece of property? Okay, and I know you're not here for that piece of property, so I'm not make a fool of myself a second time. Well, officer, if you're ready,
Yes, sir, thanks. Case number 17800000072705 South Diston. The listed owner is Milaios Pladakis. The initial inspection on this property was February 10th. There was numerous violation. The house suffered some significant fire damage approximately 10 years ago, and it's not been repaired since that point. The lot has trash all over it and appears to be used as a dumping ground. The fence is in poor condition and dilapidated, and there's also a number of Brazilian pepper trees on the property. Exhibit number 1 that's being passed around are the photos that were taken initially back in February, and I didn't take any, I don't think I took any more recent photos. They're all the February 10th photos, because basically it hasn't been touched since I took those original photos. All of my notices, including my notice of violation and notice of hearing, certified return receipts are exhibit number 2 being passed around. Exhibit number 3 consists of the administrative documentation, property appraisers, screenshots documenting the owner of the property. And for the record, the owner was derived via the Pinellas County tax collector and property appraiser's website for all notices submitted on this case. February 13th, the notice of violation was mailed first class, return receipt requested. February 27th, we received the certified letter signed by Manny Kladakis, who is the owner. It's much easier to pronounce Manny than his original name. March 13th of this year, received a phone call from Manny's mom, Harriet Kladakis, basically going through needing time and so on and so forth, but unfortunately Harriet's not the property owner. On March 16th, Officer Mike Roki conducted the reinspection for me because I was out on medical, and there was basically no change to the property. The notice of hearing was mailed first class and return receipt requested at that time, and we received a return receipt March 29th for the NOH for the notice of hearing. Officer Roki posted the property on March 30th of this year. That's exhibit number 4. And then I conducted the reinspection on April 11th, and I actually met with Manny and his sister at the property and met with the contractor. His intent was basically to ask the board to give him 60 additional days. His plan is one of two. He says he's already got the structural engineering side cleared where they could rebuild the property. But the cleanup he wants to do right away, and that's one of my biggest concerns, which includes basically clearing everything off the property, all the trash. There's a structure around back. It's like a lean-to shed that's falling over. There's broken glass. And then the pepper trees. And he agreed to get those taken care of right away. If for some reason they found that they were unable to get the clearance from the structural engineer, he'll pull a demo permit and demolish the property. Otherwise, he's going to be getting the renovation permits within that 60 days. I told him I'm okay with at least pulling the permit and beginning the work within 60 days, and at that point, the case would basically be satisfied. But since we're before the board, if he's found guilty, he would become instantly being fined if he surpasses that time frame. So that was the gist of our discussion. So yes, I did have contact with the owner, and that was what our plan was. And that's all I have at this point.
any of the board members have questions for the officer?
I was kind of looking at the stuff, and I might have said, how long do you think it'll take them to come in?
The cleanup, they're in the process of trying to get a roll-off, a couple of roll-offs up there, because there's another case that you're going to get that they're the owner of, and they're trying to take care of both those at the same time. So, I mean, realistically, a few weeks.
Okay.
The 60 days, the discussion we had about that was also to include getting permits and getting the structural redesign part of that done as well. The cleanup, though, I would imagine would be done probably within a couple of weeks.
And that's what we're concerned with today, this the cleanup?
Well, you still have 840, which deals with the structure itself, and that's
Okay.
why I said, if you got the permit, either the demo permit or the building permit, we could basically comply the case. And if he failed to do something with it, it's easy for me to bring it before as a repeat violator.
Okay, so 2 months. Thank you.
And then, one last thing, Mr. Chairman, at the end, if in fact this case is found in violation, if I could have the opportunity to suggest a penalty at the end prior to the board.
Sure.
Thank you.
All right, anyone else?
I have a question for Officer Gasson. In the notice that was posted, it also reflects 42.00 parking and storing of recreational vehicles. Are you moving forward on that particular violation? Because I didn't see it here in the list.
I'm
but
hedging that that's a typo. What was the number, sir?
42.00, and it was in the notice of posting.
Yeah, because all I have is 822, 840, 852, 3603, 13302. I don't have anything about 4200 for the recreational vehicle. I don't have a violation of that ordinance.
I think if you review the photographs, there's a photograph of what looks like a trailer.
There is a trailer parked on the property that they're having removed, and I just don't have it listed on my notes on my agenda. So, but there is a trailer that's unregistered. It's more or less in the driveway of what you could consider a driveway. There's concrete under a bunch of grass.
I just want to make sure, for the purposes of what the board is hearing, though, you're not seeking a violation of 42.00.
That's correct.
Okay.
Any further questions for Officer Gasson? Any need to discuss amongst the board, or can we go to
I
a
do
vote?
have
Go ahead.
an order question. Is there going to be discussion between first motion and second motion?
Normally, you only discuss the motions. You don't discuss the case. So it would be, after the motion is made and a second, and then there would be discussion about anything that you would want to relative to that particular motion. And then the same thing with the second motion relative to the penalty phase.
I'll have to apologize. Formerly, in my railroad career, I handled a lot of processes somewhat similar to this, and there was always discussion initially, so I kind of have to retrain myself. So I'll apologize. I won't call for any discussion until after the motion is made. And apropos of that, would anybody like to make a motion?
I'll make a motion. I move based on the testimony, evidence, and facts presented in law that at the time the alleged violations, sections 822, 840, 852, 3603, 13302 of the Code of Ordinance of the City of Tarpon Springs was forced and in effect, the respondent was in violation thereof. Second.
Okay, we have a second now. Anybody like to bring up anything to discuss in regards to this? Any need for discussion?
I do, actually. I just want to make, before the motion for a fine, possible fine on this property, I just have a question. I know the owner requested 60 days, but after looking at those pictures, that property's been in disarray for a long time. And I think to give him an extended 60 days over something he probably should have done a year ago is an extension we don't need to do. So I would suggest to the board maybe 30 days.
Any further discussion? And can we have a roll call vote, please?
I was hoping.
Oh, I'm
to-
sorry. What? Okay.
I know you guys, we're doing this a little different. The discussion I had with them was 60 days because of the permitting process and getting the permits. I made it very clear to them that if within 60 days, I was going to request a fine of $100 a day to take care of it. And based on, I have this property, I have a sinkhole house next door that I'm going to be bringing soon, trying to get those both taken care of in an expeditious process. The other thing, you guys may have remembered when Harry Kladakis was up here last year, this property was given to her husband, and they have since, as they've been going through the estate progressively, they're finding more and more properties that he owns that they originally didn't know about. Manny only found out about owning this property probably about 3 or 4 months ago. And he also got right after he found out, I drop a notice of violation on him. So understanding your point, he hasn't known about the property being theirs for 8 years. It wasn't originally his. It was only sold or kind of given to via quitclaim deed to Bill Kladakis probably about 3 years ago, and then he died about 2 years ago. And then, like I said, the family's discovering the other property that's going to be before you is the same situation. They more or less just found out about this property recently. So I don't know if that changes your opinion, and that's kind of went to the 60 days and the $100 a day, because if they do drag their feet, the penalty's already in place. That would be my suggested penalty.
I agree. I kind of felt like that because he said the house burned 10 years ago, but that does make a difference. And I think we're more about getting compliance than punishment. And so if the 60 days is what it takes, then we can back out.
Right? Anything else, Wanda? And if we're ready, we'll have a roll call vote, please.
Mrs. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Mr. Charrier?
Yes.
Mrs. Archer?
Yes.
Ms. Casey?
Yes.
Mr. DeMoss?
Yes.
Motion carries.
Okay. Now, in regards to the penalty phase, you indicated, Officer Gaston, that you wanted to address that?
I kind of did at the tail end of the other part. I think we were
Well, you
just,
threw
we were
me, though.
broken up
You
a
had
little
said
bit.
that you wanted to address it before we went to the second.
Before we make a motion is when I would like, after the penalty or the guilt phase is taken care of, I just, if it's okay with the chairman, I'd like an opportunity to speak and suggest circumstances that may, like we discussed on this particular case, that might be outside, make the board privy of those circumstances.
You want to do that now?
Well, I kind of did, and
Okay.
I would ask for 60 days and $100 a day fine
Okay.
to put into compliance based on the circumstances I already notified you guys of.
I think we all would appreciate that input because sometimes we have no idea what
Understood.
we do, so that's good.
Okay, then do we have any motion on regards to a penalty?
Maybe. Go. Yeah, you can.
This is a second motion?
This is the second motion.
just
I'm
did.
sorry, second motion.
Then I'll second the motion. I move that the respondent shall have until, oh, great, June 15th, to bring the property into compliance with section codes 822, 840, 852, 3603, 13302, or suffer a fine of $100 per day for each day thereafter the respondent remains in violation of said code sections.
Is there a second?
Second.
Any discussion? Okay, can we get a roll call vote on this second motion?
Mrs. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Mr. Charrier?
Yes.
Mrs. Archer?
Yes.
Ms. Casey?
Yes.
Mr. DeMoss?
Yes.
Motion carries.
Love this.
Okay, that brings us to the fourth case on our docket. It's case number 17-800000125, 711 South Safford. Anyone here for this particular case? Officer Gaston, if you're ready, then you may begin to present the city's position.
Thank you, Mr. Chairman. Case 17-800000125, 711 South Safford. The owner is the estate of Mr. Bill Kladakis. I was conducting an inspection on February 28th of an adjoining property next door and observed the violations on this property, which basically consisted of some overgrown grass. Exhibit number 1 are photographs taken on February 28th, and then the last photograph is one I took yesterday when I did the final inspection. And if you look at the photographs as they go around, you'll see a large tree. Their property is that very overgrown grassy area kind of surrounding that large tree. They have a large parcel, but the only part in question is about a 25 by 25 foot area kind of behind the grill that you'll see in the picture. The last picture, you can see the overgrown grass just a little bit better, kind of look behind the grill when it comes around. So the violations that I cited them for were Section 8-40 and 8-52 of City Code. All of my notices, including the NOV and the NOH, were mailed first class, return receipt requested. Those are included as exhibit number 2 being passed around. Exhibit number 3 are all my administrative documentation showing prior cases and such. February 28th, the notice of violation was mailed first class, return receipt requested. On March 7th, the certified was returned signed by Manny Kladakis, delivery date of March 4th. Received a phone call the same day as the last case, March 13th, by Ms. Harriet Kladakis. She was asking for an extension due to some medical issues and things like that. We kind of discussed that. On March 16th, the notice of hearing was mailed first-class return receipt, and on March 29th, the certified notice of hearing return receipt was received. Should be noted for the record that all the property owners were determined by the Pinellas County Property Appraiser and Pinellas County Tax Collector's websites, and all the notices were mailed to those people via that address. On March 30th, the property was posted, and that's exhibit number 4 with the affidavit of posting. March 11, I met with the property owner, Manny Klidakis, his sister. They had the contractor with them, so they're trying to coordinate everything. They thought they were going to have this done by today. Admittedly, their notice was have it done by last night. I didn't go by and look at it today, so it very well may be done. As I said before, it's a small area that basically just needs to be mowed and trimmed up. They're working on a whole host of issues with that property that hopefully will be taken care of, up to demolishing everything there or possibly rebuilding the whole property. So right now, the only case I have before the board, though, is the overgrown area that's in the pictures. And I have nothing further at this point.
Anyone on the board have any questions for the office? I have a question then. You've interfaced with the people. Do you have a sense that they're acting in good faith?
Yes, I've dealt with them numerous times. This board's dealt with them. They've always come into compliance with their things. So I have no doubt that Manny's going to come into compliance in probably a fairly short period of time. Like I said, he was hoping to have it all mowed and taken care of yesterday, but I think it was his contractor with attempting to arrange the landscaping company, the roll-offs and those kind of things, and trying to do both properties at the same time. They're very anxious to get them both cleaned up and move forward with them. So
Okay, I appreciate your insight. If there's no further questions for the officer, can we get a motion? No one
I'll
wants to
do
make a motion?
it.
Come on, Wanda.
Based on testimony, evidence, and facts presented in law that at the time of the alleged violations, 8-40 and 8-52 of the Code of Ordinances of the City of Tarpon Springs was in force and effect, the respondents were in violation thereof.
Second.
Any discussion? Apparently no discussion. Can we get a roll call vote?
Mrs. Dabbs?
Yes.
Mr. Bergman?
Yes.
Mr. Charrier?
Yes.
Mrs. Archer?
Yes.
Ms. V. Casey?
Yes.
Mr. Romasis?
Yes.
Do we want to do just the same thing as before? I can't remember the date on the other one.
It's 15th of May, June.
June.
Oh, well, if I could, speaking with them, I was going to ask the board if they would be willing to go to May 24th or a $100 a day fine. I asked for May 24th only because he's going to take care of it. I'm out of town for a couple of weeks. So if you just went 30 days on him, I would actually be out of town and I'd have to push it off until May 24th to do the inspection. So May 24th and $100 a day. And I also informed him that I was going to ask for $100 a day if it wasn't taken care of within 30 days.
Okay, but we did June.
Yeah.
On the last one.
The other one was a little different because he's got to get
Oh.
building permits. This is just
Okay.
mowing grass.
Okay, May 24th. Said,
Yeah, the other one's got a lot of cleanup.
okay, all right. I move that the respondent shall have until May 24th, 2017 to bring the property into compliance with the code sections 8-40 and 8-52 or suffer a fine of $100 per day for each thereafter the respondent remains in violation of said code section.
Second. All right. Can we have any need to discuss? All right, can we have a roll call vote then?
Ms. Dabbs?
Yes.
Mr. Bergman?
Yes.
Mr. Charrier?
Yes.
Mrs. Archer?
Yes.
Ms. V. Casey?
Yes.
Mr. Demasis?
Yes.
Motion carries, sir.
Okay, that brings us to our next case, case number 5. It's a repeat violator case. Case number 17-80000140, 738 Sunset Drive. Anyone here for this particular piece of property under discussion? All right.
Thanks,
And
sir. Officer Gasson, Tarpon Springs Police Code Enforcement. This is case number 17-800000140. It's a vacant lot west of 738 Sunset Drive. The parcel number is 11-27-15-87786-016-0040. The listed property owner is Paniotis and Tina DeVelos. As it was stated earlier, this is a repeat violator. This board established this property October 12th of 2016 for violations of the City Code 852. There were some other ones, but the case I'm bringing before the board today is 852, which is an overgrown lot. My initial inspection was conducted on March 7th of this year. The lot was overgrown. The photos included are exhibit number 1. All of my notices, to include the notice of violation, notice of hearing, were mailed first class and certified mail. Those copies and receipts are exhibit number 2. All my administrative documents, which include the prior history and my summaries, are exhibit number 3. The affidavit of the sign posting and the photograph is exhibit number 4. And we kind of took this out of order, so at the very end of this case, there's an affidavit of prosecution, which we'll have to kind of deal with as a third motion, I believe, if that's correct, Mr. Trask.
We can do it that way.
So it was kind of mixed into the paperwork, so if you happen to see it, we're going to deal with that at the end. Moving forward, on March 14th of this year, we received the return certified letter signed by the owner, Tina DeVelos. The property came into compliance on March 20th, so it is currently in compliance. And then, obviously, it was still posted on March 30th, and it was, when I did the reinspection, it was found to be out of compliance for 13 days, from March 7th to March 20th. I did have some contact with Ms. DeVelos. She advised me the property was taken care of, and that's when I went and re-inspected it. And as soon as she advised me via email that it was taken care of. So, at this point, I'd just like to find the board, the initial violation of 852 is a repeat violator, and find that for those 13 days, she was not in compliance.
Does anyone have any questions for Officer Gasson?
Where's my affidavit compliance? Where's the affidavit compliance?
Just so that I fully understand, Officer Gasson, what's before us, you're asking for a repeat violation with a fine for the dates of March 7th through March 20th, and presently it's in compliance?
Presently, as of right now, it is in compliance, yes, sir.
But it was out of compliance between March 7th and March 20th?
Correct.
13 days?
I'm asking the board to find the violation for those 13 days, and then I'll provide you guys with the information if they're found guilty of the prior board ruling.
Does anyone care to make a motion in regards to this case?
I'll make a motion,
Yes, sir.
if I can read through this. I move that based on the testimony, evidence, facts presented, and law, that case number 17-8000140 was in violation of Section 852 of the Tarpon Springs City Code from, dates. Do we have dates between the two dates?
I can give them to you. March 7th through March 20th. It's on the record as such.
March 7th to March 20th, and a fine of $25 per day for 13 days. In addition, I move that the city be awarded $136.50 for the costs it incurred in prosecuting this case.
All
right.
No, you can do it that way. It's appropriate motion. I think that what Officer Gasson was, is he just wanted to give you a little bit more input on the penalty phase of it.
Yeah.
So, but the motion's on the floor, and so you need a second, and then you can discuss it and amend it if you want to do that.
All right, let's do this. Let's open it up for
Need a second first.
oh, we didn't-
already did.
there was
Okay,
second.
I didn't
Okay.
hear you, I'm sorry.
So I believe now we can discuss it, and I believe that there's one issue was the size of the penalty, and that may be something that we would want to discuss. And also, and I probably should have made it clearer to the board that I think that we most likely would handle the affidavit of prosecution costs as basically a third motion. Is that correct?
You can do it that way, either way, and together or separately.
Is there any need for discussion in regards to this motion?
I made it.
I'm not privy to the discussion. I was going to provide you guys with what your previous penalty was going to be when she didn't come into compliance, so you could then base your decision on that. But
Was that $100? Is that
it
the
was
suggested?
$100 a
Yeah.
day. Yes, sir.
Yeah, I saw that, but because she did come into compliance, took that into account on the motion.
All right, well, let's vote on this motion then and see if we need to do anything further.
I'm sorry.
Go ahead,
I
Rhonda,
was
certainly.
looking at that paperwork and I didn't really hear the motion, so could I hear what it was again?
Certainly, sir, if you'd repeat it, please.
You don't have to read word for word. I just kind of want to know the guts of it.
$25 a day for the 13 days she was out of compliance, and then the administrative cost of $136.50.
Okay, thank you.
All right, and we have already had a second, so if there's any other further questions or discussion, if not, we'll go to a roll call vote, and I'll ask the secretary for a roll call vote.
You can have one. Mrs. Dabbs,
Yes.
Mr. Bergman,
Yes.
Mr. Charrier,
Yes.
Mrs. Archer,
Yes.
Ms. Casey,
No.
Mr. DeMoss.
No.
Your motion carries 4-2.
All right? And
That ends that one.
all right, very good. Okay, that brings us to our next case, case number 6 on today's agenda. It's case number 17-800000143. Anyone here for this particular case? Okay, this is 316 East Boyer Street. Officer Gaston, if you're ready.
I am, thank
Proceed.
you. This one's not going to be a very exciting photo case. A lot of it's going to be listening to me talk about it. 316 East Boyer Street, case 17-800000143. This is a violation of city code, the definition 838 under nuisances and 8-40. My initial inspection in this case started on March 8th of this year. That was when we responded out there as the police department to the house being shot 30 times in a drive-by shooting related to the residents of the house because of some of their drug activities and some other activities that were well published on social media. This has also occurred at this house. We've had 2 other shootings related to the residents of this property in the past. So both units A and B. Luckily, we were able to see the video from the numerous video cameras that they have around their house, so we were able to see the shooting. I sent notice to the property owners in California, which are a company that own the property, of the issues with the request that, based on the seriousness and the fact that the crimes are occurring due to their tenants, that the tenants be evicted from the property to abate the problem. As of right now, that has not occurred. On March 9th, we sent notices of violation and a notice of hearing were mailed first class. All of my notices and return receipts are exhibit number 1 that went around, and the administrative documents. Some of those administrative documents include police priors and things like that that are related to that address. The certified was signed on March 21st of this year, and on March 30th, the property was posted and a photograph was taken. That's exhibit number 3. March 31st, received a phone call. On behalf of the owner is Julie Holt from Anclo Title. She handled the closing of the property for the owners, and they very much wanted to cooperate with law enforcement. At that time, we were informed that they were in the process of doing the eviction, and we simply asked for documentation to show that the eviction had been filed and whatnot, that I could hopefully present to the board. We probably wouldn't have had this issue if the eviction had gone through. Unfortunately, that hasn't occurred, and when I checked the property yesterday, one of the vehicles that still has 14 holes in it is still parked out front, and the house still has holes in it from the shooting, and the tenants that are the nexus of the problem are still residing in those 2 units. So at this point in time, I'd like the board to find the property in violation of 838 and 840, which is the nuisance violations for serious crimes defined in the ordinance.
Any discussion?
I have a question.
Oh, I'm sorry, no, I guess we're gonna have for a motion first.
Oh, yeah.
Questions first? if
Well,
you have
any questions? I'm sorry. Go ahead.
I don't even know if this is appropriate, but on the residents of the property at this point, was there any criminal activity that has been pursued by the Tarpon Springs Police?
Oh, yeah. Yeah, and, you know, without going into too much, it's not what you know, it's what you can prove. The house becomes the nexus. And a lot of our serious crimes that are occurring in that general area, as I stated, 2 prior shootings, were related to the residents of that apartment. They've been convicted or charged with the crime yet? No, but they're the nuisance problem. If we abate the nuisance, I'm hoping that at least those issues aren't occurring at that residence. And this is a duplex that's got 2 other duplexes within close proximity. One of those rounds that went through the house actually hit a house a block south of that, which happens to be Lime Street, because this was on Boyer Street, which is 2 blocks east of Pinellas Avenue. So, and like I said in the video, you can clearly see him step out with a submachine gun and fire 30 rounds into the house, into the vehicles out front, all in retaliation for a previous theft that occurred based on one of those residents of the house. So that's just a matter of trying to prove it. I'm just trying to help clean the city up.
Any additional questions for the office?
I don't know exactly what you want us to do on here.
It's up at the top, Becky, the
Well, I would ask that the board order that in a certain period of time to come into compliance, those tenants are evicted from the property. It's a board order and it's a legal board order. That's what my request would
That
be. And that would abate the problem, was
That the owners,
that the owners evict the residents of Unit A and B of 316 East Boyer,
or they start getting fined.
or they would suffer a daily fine as long as those tenants are still there.
Okay.
Okay, but this is the thing. On City Code 838 is a nuisance violation. They were shot at, but we have enough circumstantial to state that they caused it or they were part of it? Because
If they weren't there, that shooting wouldn't have occurred because of the prior theft that occurred earlier in the day. The shooting, the attempted murder that happened, the suspect lives in that house. Hasn't been formally charged, but he's the primary person of interest in the shooting that occurred 2 months prior, the attempted murder. We recently had no less than 3 drug sales that occurred from that property, the residents of that property. So, again, like I said, the tenants of that property are causing the nuisance aspect of it. And I know this case is a little new, so we're treading in some interesting water as far as that goes, but like I said, I'm trying to do my best to clean up these problems.
Would it be fair to say, officer, that the city would be looking for support on the violation, so that during a penalty phase they could put out a penalty that would prompt the current owners to take the action that the city would hope they would take as far as evicting the present residents?
That is correct.
Okay. So you just need, the city is looking for a validation of the charge, so that the penalty phase could be such that would prompt an eviction.
That's correct.
All right.
I'll make a motion.
Go ahead then, Marty.
I move based on the testimony, evidence, and facts presented and law that at the time of the alleged violation, sections 8-38 and 8-40 of the Code of Ordinances of the City of Tarpon Springs was enforced, in effect the respondents were in violation thereof.
Any second?
Second.
Okay. Any need to discuss? Okay, if there's no discussion, then we'll go to a roll call vote.
Mrs. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Mr. Charrier?
Yes.
Mrs. Archer?
Yes.
Ms. V. Casey?
Yes.
Mr. DeMossis?
Yes.
Motion carries.
Okay, I move that the respondent shall have until April 28th, 2017 to come into compliance. to bring the property into compliance with code sections 8-38 and 8-40, or suffer a fine of $500 per day for each day thereafter the respondents remain in violation of said code section.
And we can't go that high.
Oh, I thought I saw on the
It's not a
paperwork.
repeat, so the maximum you could fine is $250
Okay.
a day.
Okay, sorry, I thought I saw something
all
on
right,
that other
Wanda.
paper. I'd like to amend that motion to $250 per day.
Second.
All right, we've got a second. Any need for discussion, or are we ready for a roll call vote? I think we can go right to a roll call vote.
That was April 28th, correct?
Yes.
Thank you. Yes. Mrs. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Mr. Charrier?
Yes.
Mrs. Archer?
Yes.
Ms. Casey?
Yes.
Mr. DeMoss?
Yes. All right, that takes us to our next case. It's case number 7. It's 17-800000145. The address is 1109 North Florida. Anyone here for that property? Okay, and both of you were sworn earlier?
Yes, they were.
Okay, thank you. If you go over to the podium, please, and give us your name, or names, I should say.
And I'm her husband, Francis Martin.
All right, you'll need to speak up nice and loud. Use the microphone. Hopefully if they're on.
Savasti Tiliakos Margillo.
And I am her husband, Francis Margillo.
All right. Officer? You're an officer also, aren't you? No? Inspector? Pardon me?
Arborist. Oh.
Oh, arborist, okay.
Let's wait until they've looked all through those.
That's fine.
Okay.
Thank you. Mr. Tryon. I'm new at this, kid.
No, you're not. Come on.
Okay. Verify these are documents that we've received.
Yeah.
Not in this situation. Okay, well, certainly we'll try to resolve that.
They have no objections? Okay, I just want to make sure we get it on the record. There's been photographs that are being tendered into evidence by the city. You have any objections to that? No? And the documents that the city is going to tender into evidence, you have any objections to those? Okay, thank you.
Okay. In this case, as opposed to having the inspector, we have the city arborist. And if you please introduce yourself for the record, you may give your testimony.
I'm Shannon Brewer. I'm currently employed by the City of Tarpon Springs. I'm an ISA certified arborist, license number FL29221-A. I'm also an FNGLA certified horticultural professional, license number H978402. This is case number 17-800001545 of 1109 North Florida. The listed owners are Sebasti T. Margello, according to the property appraiser, and Daniel E. or Michael A. Benavat, according to the owner of the tax collector.
Okay, and that raises a question, for me anyway, as to, I've sat on this board for 4 years now, and I've not ever seen this particular situation. Do we know who the actual owner is?
They are.
Okay, you are. Okay,
I can explain if you need me to. We just purchased a house a month and a half ago, so that's probably why it still shows that.
I'm sorry, can you repeat
We just purchased the home about a month and a half ago, which is probably why it shows.
that? Okay, so you're the present owners?
Yes,
Okay,
sir. And that's the previous owner, of course.
very good, thank you. All right, you may continue, please, thank you.
On March 10th, 2017, a phone call came into the City Hall from a resident at 1027 Anclote Drive. She stated her backdoor neighbor was at 1109 Florida, was cutting down oak trees, and she believed it was without a permit. Steve Wire, a coworker from the building department, called me, and I confirmed the permit had not been issued to that address. Mr. Wire met me at 1027 Anclote, where we met the homeowner, who led us into their back at 1027, who led us into their backyard to gain access to 1109 Florida property. I immediately could see two individuals in the process of removing the last few feet of tree trunk. I took a photo of that portion of tree trunk being cut down. I submitted into evidence the photos taken that day as exhibit number 1. All the photos were taken that day. Please note that the 3 photos taken by Mr. Weir have the incorrect date of 2/24/17, but they were taken on March 10th, 17. We announced who we were and the whole crew and made contact with the male homeowner. We told him that the work had to stop and we had to assess the situation. Then I explained the proper procedure, and now we had to acquire an after-the-fact permit. I took pictures of all the freshly removed trees that were now cut to the ground level with a tape measure for accuracy. I counted 6 trees, estimated diameter breast height of the trees to be 1 8-inch and 5 12-inch DBH. In the initial inspection photos, notice the change in heartwood color and pattern, the sapwood color, and the ring structure pattern of each flush cut. If you look closely at the wood pile pictures, you can correlate a flush cut to each. I went back to City Hall, entered the information for the notice of violation to the Tarpon Springs Ordinance 133.04 and 133.09, which requires an after-the-fact permit. I now submit the evidences of the NOV and NOH in Exhibit 2 and the certified receipts, all administrative documents, which include the case summary in Exhibit 3, the affidavit of posting, copy of the sign in Exhibit 4, and Exhibit 5 tree removal worksheet with the cost ×4 for the ordinance of 133.09. All notices were mailed to the property owner of record as determined by the Pinellas County Tax Collector or by the Pinellas County Property Appraiser database, first class, and certified return receipt. Ordinance 133.04 states, except for those trees, species listed as an exempt or follow a declared state of emergency in which the trees become damaged in such a way that topping or excessive pruning or at the direction of government agency becomes necessary, it shall be unlawful for any person without first obtaining a permit as provided herein to cut down, damage, top, poison, replace, replant, or effectively remove through excessive injury in any manner to destroy or cause to be destroyed, remove any protected tree with 1 or more stems or trunks 4 inches or more in diameter breast height, or to remove any mangrove variety cabbage palm or sable palm with the same size. 133.09, the enforcement. For the willful removal of any tree in violation of this code, the city staff shall ensure that proper permitting procedure is henceforth followed, charging 4 times the permit and replacement fees specified by the code. In Section E, and any prosecution under 133 through 133.10 for the removal of a tree without a permit, each tree so removed will constitute a separate offense and mitigation shall be required. The after-the-fact permit application fee becomes $100, and the mitigation fees become $5,120 for a grand total of $5,220. This information was sent to the homeowner of 1109 Florida by first-class mail and certified the same day of the offense. On the following week, the homeowner of 1109, Mr. Margello, called me and several other departments to state he was not going to pay the fees and fines because he cut 3 trees down, not 6, as the evidence indicates. So 3/10/17 was the initial inspection. Contact was made with the male homeowner. NOV was mailed first class and certified with documentation for all fees needed to be paid in order to obtain the after-effect permit. 3/15, the NOH was mailed with first class and certified. 3/29/17 was sign posting. No photo was taken due to the homeowner picking up the sign. Greg Dobbins, another city arborist, went with me to obtain the photo. The homeowner refused to put the sign back and keep it posted. 4/12, I confirmed with developmental services that the permit and associated fees had not been obtained.
The board first, though.
Board first. Any questions from the board?
Was this done before they bought the house?
No, on 3/10, as you can see in the photo, I walked up on it with Mr. Wire, and it was being done that day.
as a, if I might ask a question, as a professional, were you able to determine that the apparently 6 trees in question in the case, were they all fresh cuts from that day?
Yes, they had been
All right.
removed that day.
And it was clear to you as an arborist that there was no doubt that none of them had been done.
I saw the two gentlemen in the photo removing.
But they hadn't been fined before he sold the home?
No,
They were all
there were
live,
no priors in Navaline.
they were all live trees.
Yes. Coastal oak.
Pardon me?
Coastal oaks was the
Oaks.
actual cultivar.
Were there any trees to replace, planted, or anything like that happening?
No, not been. And they have not obtained the permit which is required.
And you indicated during your testimony that the owner acknowledged to you that he had cut down 3 trees?
Yes, that was a week after, on the 15th. Roughly then.
Sir, do you have any question, or ma'am, or whoever wants to do it, any questions for the witness?
No questions, no. But I mean, I have something to say, of course, but no
So
questions.
we're going to give you an opportunity to do that, but right now we're in the interrogatory phase, so if you have any questions. Okay, there being no further questions, I'll give you an opportunity if you
Sure, thank you.
express your position.
So, of course, I'm going to explain because my wife was at work that day and I was dealing with the contractor or tree guy. So, I hired a tree company to come in and we just purchased this home, knowing that we had to remove some trees before we even purchased the home. Of course, I should have printed this out and brought it. I didn't realize, I've never done this before. I have emailed pictures to myself of about 5 trees that still need to be cut down because they literally go right over my roof, which is why we've done this to begin with. So through a friend of a friend from Tampa, I hired this contractor to remove some trees. He said to me, because they're endangering your home, they're not required for a permit. And he went around and slapped trees that said if you wanted these removed, they would require a permit. He charged me $700 to do this, okay? I said, okay, no problem, let's do it. He came, obviously he's cutting these trees down. Now, and again, I do have pictures of the house is a little over a year old. When they cut these trees down, initially they left stumps. And I have pictures that are currently stumps on my property right now that we didn't top. So when he's trimming these 3 trees, it was 3 trees cut, one of which was a cherry laurel. So there was only 2 live oaks that were actually cut down. But when he was doing this, and he obviously cut a bunch of limbs that were around the house. But when he was doing this, he kicked to one. He said, hey, you see these stumps? Someone's going to trip over these. Would you like me to remove them? So he went and lowered about, I think it's actually more than 6, I'll be honest with you. But there's still 4 that he never did. And again, you can go to my property and still see them sitting there, these stumps. And when the young lady came with our colleague, she said, okay, what we could do is, or the gentleman said, we could fine you and put a stop work order on you, but we're not going to do that. All you have to do is get an after-the-fact permit. No problem. Obviously, I've never done this before. I have no idea what that costs. I asked the professional. He said in Tampa, obviously we're not in Tampa, but he said in Tampa it's a couple $100. I said, okay, no big deal. That's fine. They said, we're going to take some pictures. We're going to make some notes. We'll be out of your hair. You guys can continue doing what you're doing. Had I known that she was going to go take a picture of every stump, I would have simply went with her or told her what we did. I didn't realize it was per tree. I thought it was a permit for the whole job. Again, I've never done this. We have no clue as regular homeowners, how this works. I'm relying on a professional telling me we don't need a permit. I didn't do this myself. I hired someone, $5,000, due in 2.5 weeks. We're having a baby in a month and a half. Who can afford to do that?
We just bought a house. We saved all of our money to buy our house.
For 3 years. For 3 years we saved.
And then we move in and, we did the right thing. We hired somebody. Due diligence, I get it. But when the lady came to my house at 7:15 in the morning, 7:11 to be exact, because I didn't have my sign up the very next day after I called, because I wanted to put a complaint in, because she didn't do it right away. She did it the day that I called to put in a complaint. That same day I came home from work and there was a sign and it was wrong, so I took it off. She comes at my house knocking at 7:15, let's call it, in the morning, saying, why don't you have your sign up? Well, it's not right. And then when I try to ask her a question, she's like, I'm not gonna do this. You take it up with the board. I'm not gonna do this. And then she said, if we're regular homeowners, we don't know. If you thought that this is your job, if you thought we were doing something wrong, and stop us. Say, no, you have to stop right now. We'll be out of here. We're gonna take a couple pictures, we'll be out of your hair. If you have questions, take my husband with you and have him explain what he did to you. But then she says, well, I assumed. Those were her exact words. I assumed that's what you cut. And I said, I'm not gonna pay over $5,000 because you assumed. I mean, it's ludicrous, $5,000. I'll pay the permits, but I can't even afford to pay $1,000. I mean, not a normal person is not a homeowner is not going to know the laws, or that's why we hired somebody. And we said, if we do those other trees in the back, those are big boys over there, then we are going to need a permit. But these are hanging over your roof, and we couldn't afford to do all of them because there's a lot of them that are over our roof, and we were going to do it in pieces because we had a lot of expenses moving, so we weren't going to do it all at once. So if I would have known that this was going to happen, I would have never even,
Obviously, yeah, we wouldn't have done it, but, yeah. And again, I didn't print pictures. I have before and after pictures, thank God. I actually have a picture of his truck with all of the debris on it, showing you that it is clearly not 6 12-inch trees.
Is there a reason that you don't have those pictures?
I didn't know it was like a trial. I mean, I didn't know how this was going to be, to be honest. I figured I emailed them to myself, figuring I can email them to someone to see them. I don't know. I apologize. After I saw the first cases with pictures, I immediately thought I should have printed them out. But I can show you on my phone right now if you'd like.
We're willing to plant trees.
Yeah, I mean,
we didn't do this with an intent to do anything. Obviously, it's a mistake. We didn't do it ourselves, and we hired a company. We hired a company to do it.
And I know sometimes you guys, I've heard, allow people to replant trees. We currently have, I counted this morning, 29 live oaks on our property right now.
It's a small lot. It's not
And
even,
it's we don't have a lot of property. We have more trees on our property than anyone around us. And again, we'll plant the 2 back for 4 back. I mean, we just can't afford anything like this at all right now.
I'd like to ask the arborist, do you have any questions?
Did you call the city prior to hiring the company to find out what the ordinances were?
again, we hired a company that was
No,
licensed.
to answer your question, no.
Did you hire a company that was licensed?
Yes.
Yes.
Did they advise you about permits?
Yeah, he did.
He said, we do not need to pull a permit. If you pulled that bad boy,
Say that he
yes.
was going to take care of the permits that were needed.
What was the question?
Did your company say that he was going to take care of permits that were needed?
He said there was none.
He said no permits were needed because they were endangering the structures, is how he put it. Which again, we still, again, I would wish someone would go to my property. There are still trees over our roof that we didn't remove. Thank God.
Any further questions for?
No.
I guess, does anyone have any questions for the arborist?
Yeah, I must have missed this. What's the sign that we're talking about?
The posting for the notice of hearing.
And if I can elaborate on that, it's an orange sign about this big on my front lawn, accusing us of something that is inaccurate. We did not cut down 6 trees. If it said 3 trees, fine. And when we asked, is this required to have this sign? Are we going to get fined for this? When they were there that morning and they said, no, it's up to the board. So I'm sure you can understand why we didn't want, there were new neighbors in the area. It's kind of humiliating.
It's embarrassing. Like, oh, here you go. You haven't been, accused of being guilty yet, but you have to have this big orange sign. But then you only put it the day that I call, which is almost a month after. To me, I'm taking it personal.
It's kind of personal, yeah.
Because, you know what I mean? If you would have done it right after, okay. But the day I called, and I called the police department 3 times. I spoke with an Officer Roque. Okay, I spoke with an Officer Roque who was supposed to get back to me. I even spoke to Sergeant, he's a sergeant now, I forgot. have it in my name. I have it in my phone. But he suggested that I call the police department the next day if I couldn't come in, and I have to work, so I couldn't. So I called the next day, and I spoke to Officer Rope, and he said he was gonna find out, because he didn't know, because I was told to put a police report on this because it's unfair. And I did that, but he never called me back. I called 3 times. I mean, I called the city. I mean, I did my due diligence. I don't know. I can't afford to pay this bill. I can't. I'm having a baby.
Well, I'm curious, why don't you want trees over your house?
Because if any storm happens, that's it. There goes my roof.
Well-
And there's leaves that keep falling, and it holds water, and then it makes the roof collapse after.
So I'm a realtor for a living, and when you have trees over a house, it collects a pile of leaves, which in turn makes water damage to your shingle. It makes the water back up into the shingle. So anytime you have a pile of leaves on your roof, it becomes a problem, and it's a new house.
The flat roof?
I've got a question. Oh, I'm sorry. Wonder you.
No, that's,
I've got a question for both sides in this. You've indicated that on the date in question, you only took down 3 trees?
3 trees.
Okay. And the contractor that you hired, are you including whatever he did that day at your request?
Well, yeah, those are I didn't cut any. Personally, I didn't touch the train saw.
Okay, so there were only 3 trees taken down that date, and they were all done by the contractor.
That's correct. And obviously a lot of limbs. He removed a lot of limbs from trees that are still standing because they were over the roof.
And you're indicating that he indicated to you that they were over the house and therefore potentially dangerous.
Correct. Well, he indicated, I knew they were dangerous because of my expertise, but he indicated to me that a permit was not required because they're endangering the structure. That's what he said.
Let me ask the arborist, please. You've just heard the testimony. Do you agree that it was 3 trees that were taken down that day?
I found 6 fresh, lush cuts on that
6
day.
trees.
I found
Okay.
6.
Were
Well-
any of these trees in such a position that they might have caused a danger to the homeowner?
They were on the ground and the flesh cuts were there except for the last stump that I saw being removed.
Well, from the location of where the stumps were, did that give you, as a professional arborist, did that give you any, can you form an opinion as to the spread of those
lane?
trees potentially? And based on that spread, could it have at least potentially been a danger?
They were young. I did not see any severe decay in the wood pile. As you can see from your photos, they are very young. Oaks compartmentalize well, and they compartmentalize decay well. If they were a danger of that nature, it would have been seen in the pile.
Okay.
I have a question.
All right, and by their very nature, with trees, if in fact a tree were over a house, would it or would it not necessarily cause a potential problem?
Depending upon age, which these are relatively young as compared to other ones that I see throughout the city, these were young trees. These were young, healthy trees.
And the last question I have, because I certainly don't know anything about trees, we indicated that, or the city has indicated that there's a mitigation fee. It seems to be a lot of money. How was that total determined?
By the city ordinance in if this is .4, the permit required, I believe it's .3, the one above that, has all the fees, and it's listed in 133.0 through 110.1. It is predetermined. I did not choose those fees. That is something that the city has in their
Okay,
ordinance.
so that's based on established procedure, and that's not an arbitrary
The
decision
removal
on your part.
worksheet is a city document, and I just go on and I fill out the city document with the amount of interest.
And again, I may have spoken over you. That wasn't an arbitrary decision on your part. That's based on.
I measured the flesh cuts, estimated for the rate of growth, that those would have been the DBH or diameter breast height of those trees.
Question.
Certainly, go ahead, Mrs. Archer.
Whether those trees were bothering the roof of the house or in bad shape, if they're a certain type of tree,
It is protected.
you have to have a permit
Have a
for them,
permit.
correct?
Correct.
Whether, no matter what.
No matter what.
Yeah.
and I have another question. I believe their testimony is that 3 of the trees were already cut down, just a stump was sticking up, and the tree guy said, let me flatten these so nobody falls down. Is it possible that they only really took down 3 trees and those other 3 were just cut to the ground?
From what I saw, the amount of wood, that is indeterminable because I don't know what the height of those trees were. And if they had gone to the dump previously before I got there, that would be undeterminable.
I'm not sure if this is a okay question, but
Go ahead.
if they had pictures of their yard showing that there were only 3 tall trees cut, would that make a difference in this case?
But he still does not have a permit.
I-
The permit was not obtained.
I
And
understand.
that is the gist of why I'm here. This is about, did they cut trees down without a permit
Oh.
or not?
Yeah, I believe that happened, but I'm just thinking the amount of that fine, that 5,000, if 3 of those trees were just stumps, that there's a big difference in the fine.
Let me jump in, give you a little bit of direction here. It's not up for you to determine the amount of the fine relative to the permitting. You're to make one determination today and one determination only. You're not to count the number of trees. It could be 1, it could be 500.
Okay.
You make determination whether the violation exists. Did they cut down trees without a permit? That would be a violation of section 133.04. Don't get caught up in the details on that particular type of stuff because that's really the issue. And as for the enforcement section 133.09, if you find that there is a violation there, then that's what you should determine. Then you would assess a dollar amount of fine per day until they bring till they get the permit. So every day that they sit back and say, I'm not going to pay the $5,000 is another day that they're going to get not only the $5,000 fine, but they're also going to get a whatever daily fine that you attach to it. So they have the right to appeal the decision of this code enforcement board to the circuit court, and they also have the right to appeal the permitting process to the Board of Adjustment if they wanted to do that under 133.10. But don't get caught up in the number of trees, when it was cut, that type of thing. You should just determine whether or not that there was a violation of those 2 code sections.
All right, the board appreciates your insight and interpretation, Mr. Trask.
Well,
Any-
could
Any further questions?
Mrs. Yeah, I'm
Yeah, how close in proximity was the trees to the house? Because we don't have any pictures to show if the tree tops were over the roof or not. So, and I'm not sure if you can still tell the close proximity of the
That
stump.
doesn't make any difference.
Are the trees top went over the roof? What protection is there? Isn't there something?
No, there's no exception for trees over the roof. The arborist has just testified. It doesn't matter whether they're over the roof or not. They still need to get a permit. That may be a justification to get the permit, but they haven't gotten the permit. So the arborist is saying that that's required under the law. As for photographs, this is the opportunity for both sides to present their case. The city has presented their case. The alleged violators have presented their case. They may not have done it the way you wanted it to be done or the way they wanted it to be done, but that's the case. And so you have to make your decision based upon the testimony and evidence that you received today.
Something? Can I say something?
I'm going to give both sides, because there's been a lot of questioning, both sides a chance to give a closing statement.
Could I have one more question?
Certainly.
Would they have been granted a permit to remove the trees over the house had they applied for, had one been applied?
I did not see any decay in the pile that I saw. Not sure how much other wood was around from what I was left on the ground. I could not make that determination.
I guess my question is, for the reason, if the trees were totally healthy, for the reason they wanted to remove them because they were concerned about their roof, would you grant a permit to let them?
The trees were not there. I cannot say that either way.
Are you in a position to grant permits, you yourself?
Yes.
If an insurance company tells a homeowner that a tree is harmful to their home because it hangs over their house and either varmints or the tree itself could fall, okay?
If it is a hazard.
Yes, if it's a hazard. And since they're younger trees, we really don't know whether or not a good wind would blow them down or not. A more mature tree, I can see your point of view. But since these were young trees by your own testimony, there's more likelihood that that could have fallen on the house. So based on that, would you have given them a permit?
These trees were healthy. Oaks are great compartmentalizers. From what I saw, I think I probably would have required mitigation for these trees.
Wind mitigation?
I would have required mitigation be obtained for the removal.
Let's say that happened, and there was enough, maybe, possibilities that the tree could have fallen. Would you have given them permit?
From these trees, from what I saw, from the young nature of the wood, it would have been able to be more resilient and withstand the wind, more so than.
You just contradicted yourself.
No.
You said before,
That the young, I guess what, the younger trees would be able to withstand the more wind, from what you're saying, if they were leaning over the house, than an older tree that.
but could they have fallen?
Yeah.
With a good wind, 30, 40, 50, 60, 80 miles an hour, 110 miles an hour.
Oh, God.
Well, could they have fallen? That's the question.
I don't know if she
Unknown.
can answer that.
They couldn't have fallen. Really?
Unknown, the trees were not.
Unknown.
completely-
Okay, thank you.
Well, I don't know that it's necessary for us to argue with the witness.
I'm not arguing, I'm questioning her.
Well, I think that, I just want to caution everybody that we'd like to make sure that we all display prudent conduct. So, and I know that, sometimes with issues, we become a bit vehement, but I'd like to make sure that we understand that, we really need to
Let me
use
ask you
prudent
something,
conduct.
Mr. Chair. Are we a court of law?
No.
Okay, so as not being a court of law, we would want to know whether or not something is fair and just. And if it's not fair and just, regardless of what the ordinance says, we are to act on that.
No, I think we have to, the ordinance is the ordinance. I'm not sure it's up to us to make choices. It's up to us to determine whether the ordinance was violated.
Okay, I'd like to make a note that I disagree with that.
Oh, you can disagree with it, sir.
Okay.
But let me ask Mr. Trask, you're the legal expert here. What is our purpose?
It's a quasi-judicial hearing. It's not a court of equity. You're not to weigh the fairness. You need to make sure that due process is given. You need to make sure that the essential requirements of the law have been observed. But it is not, you don't weigh each ordinance as to whether or not you agree with it. It's whether or not there has been a violation of it. So, but I think I understand the questions that were being asked, but I don't think that the answers have been clear, and maybe I can ask the questions in a way that'll make it a little bit more of a difference.
I'd appreciate it if you would, Mr.
Okay.
Trask.
When you have a tree that is in some way harmful to the home, you would issue the permit. You just wouldn't require it to be mitigated, correct? In other words, they wouldn't have to replace it.
Correct, there's other factors that are involved as well.
Okay. If it wasn't a tree that needed to be cut down for the purposes of harming the house, you would have given the permit, and they would have just had to have replaced it with another tree and pay the fee. So that's really the distinction you were trying to refer to,
Yes,
right?
and I didn't know how to properly word it. Thank you.
Okay. So if it's a bad tree, you don't have to replace it, but you still have to get the permit. If it's a good tree, you have to replace it and get the permit.
Correct.
Okay.
Thank you.
All right, and Mr. Shree, any further questions? Because I know it appeared I tried to cut you off, and I want to give you an opportunity if you have a further question. Go ahead. Okay. Does anybody have any, or if you're ready, you have a closing statement? That was what I was about to ask you to do when a few questions further were asked. Any
I'm
closing statement?
From my determination, they removed 6 trees, flush cuts, and without a permit, and that is the violation.
All right. Sir, any closing statement you'd like to give before we ask for a motion?
Again, I would just like to say, we obviously just spent all of our money purchasing this home. I have 29 trees currently on my property that are 10 inches and bigger in diameter, so big trees. I don't have extra money. I'm sure no one does. I would not pay someone to remove trees that did not need to be removed, which is why there's still 29 on my property. Why would I spend my money for no reason? I mean, I don't know what else to say. I mean, that's what happened. I have no reason to come up here and lie. Had she asked me that day what we did, I would have walked with her and showed her.
And not
But she
say
assumed and took it upon herself to say we cut down 6 trees when that is in fact not true.
And if you knew, you know, my thing is, as well, is if you know that I'm doing something wrong, I don't know it, and you say I could put a stop order and fine you, but just make sure, you know, once we leave here, you get an after-the-fact permit. And we're like, okay, we will. But then a day or two later, we get the letter. You didn't even give me a chance to get an after-the-fact permit because you said that this is the after-the-fact permit times 4. It's ridiculous. If I'm the homeowner, I don't know these things. Yes, and I understand that there's a due diligence. That's why I hired somebody. But for me to pay $5,000 for trees, I'll plant some, again, on top of my 29 that I have. Or, you know, if you thought that I was doing something wrong, you should have said, stop right now, you know, and then get the permit, and I'll pay the money. But don't tell me, well, that this is, right here, this is the final amount, $5,000, this is the permit.
That's more like a fine than a
Yeah, that's, you can't say that. I mean, you're the professional, this is your job. If you think I'm doing something, that I'm violating something, then stop me. Don't say we'll be out of your hair and you can keep working.
And to touch on that a little further, and I know you guys are busy, but we could have kept, that day she said, keep going what you're doing. We could have cut down another 10. We didn't know that I'm charged per tree. Do you understand what I'm saying? Thank God we didn't, but it could have been so much worse because we just weren't given that information. It was such a awesome, like, chatting about other things with these guys. It wasn't, I did not, when we got this in the mail, I almost fell to the floor. It was not at all what we kind of discussed. Like, it was just going to be a couple $100, you know, after the fact permit. You know, I don't know.
Anything
We're just
further?
looking for, you know, your guys' sympathy. I mean, it's obviously that we wouldn't have done this had we known that this was going to happen, clearly.
All right, can we get a motion?
I'll make a motion.
All right.
I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, 133.04 and 133.09 of the Code of Ordinances of the City of Tarpon Springs was enforced, and in fact, the respondents were in violation thereof.
Any second?
Second.
Any discussion? Mrs. Archer?
I don't, if I'm talking out of turn, just tell me, but are you new? Can I ask them a question?
Certainly.
Are you
I
new
guess.
to the area?
I'm sorry?
Are you new to the area or
I-
Tarpon Springs?
Tarpon Springs, yeah, I just moved from Riverview. I've lived in Florida for 6 years.
But I used to live here, I grew up here, and I moved away when we met, and we're having a baby, and I wanted to be closer to my family, because I'm gonna
Oh,
go
I
right
just
back to work, so.
I want to know if you would live in, I just feel that they kind of got taken from from the people you hired. They didn't tell you the truth. They didn't tell you, or they didn't know I don't know.
And I can't even get a hold of these people either.
I think
I don't know if
I
that helped.
would ask you, I think you had your opportunity to discuss it, and I allowed Ms. Archer to ask you a question, which I think that puts an end to that situation.
Yeah.
So, any discussion among the board?
I know that we've had a lot of cases where people said they didn't know they needed permits, but it's kind of like, that's just not a good excuse anymore. We can't, ignorance just, is still a violation.
Well, the people that they hired, they should know better.
Well, I would just point out to the board members to consider that we've heard testimony. There's a big difference between 6 trees and 3 trees. So we'll have to decide, each of us, which witness we feel gave testimony that was closer to the truth. That to me is an issue. The fact that the arborist said 6 and the owners say 3. That's something that you may want to consider. Any other discussion? Wanda, do you want to say something? No? All right, then let's go to a vote. Can we have I'll ask the secretary, can we have a roll call vote, please?
Mrs. Dabbs?
No.
Mr. Bergerman?
Yes.
Mr. Charrier?
No.
Mrs. Archer?
Yes.
Ms. Casey?
Yes.
Mr. DeMontis?
Yes.
Motion carries 4-2.
We'll continue.
Yes.
I move that the respondent shall have until the 27th day of April, 2017, to bring the property into compliance with code sections 133.04 and 133.09, or suffer a fine of $25 per day for each day thereafter respondent remains in violation of such code section.
Any second?
Second.
Any discussion?
Yes, is that above the $5,000?
That's correct.
Yeah, but the thing is, that gives them 2 weeks to just go get a permit. It has really nothing to do with the 5,000. It's just, that will bring them into compliance with what they are being cited for. So they're, if they just go out and get the permit tomorrow, the fine won't exist.
The $25.
Right.
But the 5,000.
Yeah, but that's not our job. That's an assessment made by the city. We're not dealing with that. Is that correct?
That's correct.
But that's an assessment based on 5 trees. Is that
But
correct?
that's between them and the city. That's our
That's
job
based on
here
six,
is to see
on
if they're in
6 trees.
violation of not having a tree permit. And we found them in violation of not having a tree permit. We're not counting trees, and we're just trying to get them to get a permit.
Any further discussion? Can we have a roll call vote?
Mrs. Dabbs?
No.
Mr. Bergerman?
Yes.
Mr. Charrier?
No.
Mrs. Archer?
Yes.
Ms. Casey?
Yes?
Mr. Moses?
Yes.
The motion carries 4-2.
Hey, Can I go ahead and summarize it for them?
Yes,
Okay.
in fact, I was going to ask you, Mr. Trask, just so that everyone knows what the situation is, because it was a rather complicated case.
Okay, just so that you understand what has happened, the Code Enforcement Board has found a violation. You have until April 27th, 2017 to bring the property into compliance. The way that you bring it into compliance is obtaining the permit. If you fail to do it by April 27th, the $25 fine will be assessed for every day that you don't have the permit. If you have questions about what happened at the Code Enforcement Board meeting today, you can speak to the arborist or the Code Enforcement Officer, Officer Gaston, after the meeting. And my suggestion is that you probably will want to go down and talk to them immediately about counting the number of trees, and maybe there's something that can be reassessed on that aspect. If you don't feel like you want to go that way, you have the option, as I had mentioned before, to appeal this decision before the circuit court. You have 30 days in which to do that. You also, under section 133.10, have the right to appeal the permitting decision to the Board of Adjustment. They meet monthly, and there's a process that you'll have to go through to follow through on that if you want to go before the Board of Adjustment. Okay?
So just that we're straight, you have to pay $5,000 by the 27th?
You have to get your permit, whatever is required. Or if you don't, it'll be an additional $25 or a day fine.
In addition to the 5,000?
If that is what the calculation is, that's correct.
So as far as us getting the permit, like when I go to try to pull a permit, it's already like programmed online with 6 trees. How do I'm obviously disputing that, so.
You can go talk to the city arborist, or you can talk to the code enforcement officer sitting behind. I would say that you'd start with the arborist.
Okay.
Okay?
And then disputing this, going higher, what's the process to do that?
I just told you that. You can appeal it to the circuit court, or you can appeal the permitting decision, it looks like, under 133.10 to the Board of Adjustment.
Okay,
The different board.
gotcha.
Okay?
Okay, that brings us to our next case, case number 8. It's case 17-8000067, 704 Palm Avenue. apparently we have somebody present for that case. Ma'am, if you would introduce yourself.
Good afternoon, Board. My name is Jaleh Paran-Visse, and I am the attorney for the guardian of the owner of the subject property, which is Cynthia Nedick. The other owner as listed, Gary Nedick, is deceased and has been so since 2015. I've already seen them all too. She's already submitted them to me. Thank you.
Any objections?
No objections.
Okay, so we're going to receive it in evidence, some photographs, the notice of hearing, notice of violation, without objection.
All right, then. If we're ready, would the city arborist present your position, please?
This is case 17-800000067, 704 Palm Avenue. Like you said, Cynthia Nedick is on record on the public appraisers, tax collector. The area of Gulf Road and Tarpon Drive and Palm Avenue is under attack by pine borers. Upon finding an active borer colony, all trees in the surrounding area must be inspected. This is how I came to find the active colony at 704 Palm. On January 31st, I observed 3 pine trees that are dead and severely damaged from pine borers, and also have an active pine beetle larva at the property, and made contact with a female at the residence. I tried to explain about the insect, how quickly it can spread throughout the area, and how the dead wood becomes very unstable because of all the tiny tunnels made by the insect. The trees are hazardous and need immediate removal. Enter Exhibit photos, and Exhibit 1 photos. Exhibit 2 all notices, including courtesy letter, NOV, and OH certified mail receipts. All notices were mailed to the property owner of record as determined by the Pinellas County tax collector by the Pinellas County Property Appraiser database. They were in violation of Ordinance 133.02, applicability of maintenance. Owners of private property are responsible for the maintenance of trees on the private property and in abutting right-of-ways. All plant material shall be maintained free from physical damage, injury arising from lack of water, chemical exposure, insect, disease, blight, or other causes. The deadline for removal for the NOV was March 1st. On February 9th, the attorney, Jaleh Paran-Visse, requested an extension, and I explained about the finances being tied up in court. I inspected 3 trees again and did not feel comfortable granting the extension. I also asked Keith Mead, another arborist who works for the city's building department, to complete an inspection for a second opinion. I submitted Exhibit 3 administrative documents, including the case summary, emails from the attorney, property appraiser, tax collector records. Exhibit 4, a copy of the signed affidavit for the posting with the photo. Exhibit 5, memos from me and Keith referencing the evaluation of the hazardous trees and basic tree assessment form. Exhibit 6, the document that the attorney plans to submit. February 16th, Mr. Mead conducted his assessment, and his result states 4 pine trees located at 704 show signs of severe damage due to borers and have active pine beetle larvae found at the base of them. They cannot be saved and need to be removed, as they pose a risk to persons and property. There is no way to determine exactly when these trees will fail, but they need to be removed as soon as possible. I forwarded all the results to the attorney. On March 13th, I re-inspected the trees on the property and the surrounding area. The 3 trees had not been removed, and they were last remaining green pine at 704 Palm was now dead. Since these trees remained on property so long, the borers have moved deeper into the urban forest. On April 3rd, an email was received from the attorney advising the intention to appear here at the Code Board, PBE, and requested an extension and waiver on all fees and fines. I told her I'd be satisfied if the trees were removed by May 31st, 17, due to the situation with the finances. After that, I leave to the discretion of the board.
Does anybody on the board have any questions for the arborist? Does the representative of Mrs. Nedick have any questions for the arborist?
No questions.
Then I would ask you anything that you'd like to present to support the position of the alleged violator.
Yes. So my client's not contesting that there are dead trees on the property. This is something that the arborist and I have discussed. She's sent me pictures. There definitively are issues on the property with respect to the trees. The main crux of the issue here with respect to getting the property in compliance is the property owner, Cynthia Nedick, does suffer from advanced stage dementia. She is under a court-ordered plenary guardianship of the person and property in Pinellas County, Florida. Letters of guardianship were issued to her daughter as the guardian on November 4th of 2016, and I am the attorney with respect to the guardianship. In the guardianship, there is a court-restricted depository, which all monies that belong to Cynthia Nedick are deposited into. In order for my client to be able to act for her mother to bring the property into compliance, we have to have court approval. So as soon as receiving the information from my client on or about February 9th, I did contact the arborist, as she stated, requesting an informal extension in order to get the property into compliance. In the interim, her and I discussed the matter. She basically did not believe that she had the authority at that time due to the hazardous nature of the trees being a persistent issue with damage to person and property, my client as well as the surrounding property owners. I have filed a petition that was filed, and I do apologize, I did not bring copies, but I did email the documents which I filed with the court, which include the letters of guardianship as well as the order appointing guardian. But there was, and I hope it's before the board today, but March 3rd of 2017, I did file a petition for authority to act with respect for authorization in order to remove the trees. I did have to provide the court with 2 quotes for the removal of the trees. At this present time, I have been following up with Judge Allen's judicial assistant. Unfortunately, the way that probate and guardianship works in Pinellas County is that you have 2 layers of approval that you must go through before you can get that authority, first to the general magistrate and then to the actual judge. At this point, it has been over 1 month since I have filed that petition. We are still diligently checking on that to see when the court enters it. I have absolutely no belief that the court will not authorize this action, again, due to the issues that are present and the violation. We did discuss a deadline of May 31st in order to come into compliance. I do not think that will be an issue. I am very hopeful that the court will enter the order, allowing my client the authority to access the funds prior to that time, but in an abundance of caution, I have requested until May 31st to get that into compliance. The only thing that I would request would be due to no fault of my clients and not being able to access the funds. Again, we do require a court order that she not be penalized with any fines or fees with respect to the violation.
Does anyone have any, do you have any questions? I've asked the arborist, any questions for the witness? Any board members have questions for the attorney? I have a question for the arborist then. Can you tell us, you just heard Mrs. Nedick's attorney testify. Any problem with the date that she's indicated? That's an acceptable date for the city. Okay. Based on that, can we get a motion?
Okay.
It's your new job, Wanda.
I move based on the testimony, evidence, and facts presented in law that at the time of the alleged violation, I don't see a number.
City Code 13302.
City Code 13302. Of the Code of Ordinances of the City of Tarpon Springs was in force and effect. Respondent were in violation thereof.
Second.
Any discussion? We have a roll call vote, please.
Mrs. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Mr. Charrier?
Yes.
Archer?
Yes.
Ms. V. Casey?
Yeah.
Mr. DeMossis?
Yes.
Your motion carries.
Okay, and that brings us to a second motion, Wanda.
Okay. I move that a respondent shall have until May 31st, 2017 to bring the property into compliance with the code section 133.02 or suffer a fine of $50 per day for each day thereafter the respondent remains in violation of said code section.
Second? Anyone?
Second.
Any discussion? We have a roll call vote.
Mrs. Dabbs?
Yes.
Mr. Bergerman?
No.
Mr. Charrier?
Yes.
Mrs. Archer?
Yes.
Ms. Vaquesi?
Yes.
And Mr. DeMoss?
Yes.
Motion carries 5-1.
Okay, so,
I'll go ahead and summarize then. So the property owner has been found in violation, been given in 133.02, given until May 31st to come into compliance. Should the property owner fail to come into compliance within that period of time, it's a $50 a day fine. Your client also has the opportunity to, if he doesn't meet it within that 5/31 time, to come back and petition the board for reduction of the fine. You have 60 days in which to do that from the date that it's brought into compliance.
Thank you.
So we got the affidavit of non-compliance, so he's going to make his presentation. And then you have these two motions. Affidavit of compliance and no fine, or affidavit of compliance with a fine? Jen, you're done.
Yes.
You're done.
okay, thank you.
Can we ask her a couple of questions? just off the-
Oh, that's somewhere here.
SHANNONBREWER.
That's, yeah, I don't have a problem with that, but it shouldn't be about any cases that we've heard today.
Okay, but as long
I
as it's
know.
not
Okay, they
about-
won't ask you for your
Okay.
tag number, your
Never mind.
license number,
All
or
right,
any of these
that-
things. You're good.
I believe we're,
Nobody will do.
I believe we're finished. Thank you very much.
Sam?
Acceptance. What do we do if there's no fine set on the acceptance?
Well, we got the affidavits of non-compliance first.
Right.
Yeah.
And it wants to know a dollar amount for costs incurred and.
Yeah,
incurred.
just to help the board out a little bit with that first case where it says the fine's not set, we kind of changed the process. That was the one case we heard a couple months ago. And a daily fine wasn't assigned at the time, so we kind of have to deal with that now that it's not in compliance, and you basically assess a daily fine for it. So, moving forward.
Okay, so we have before us case 16-800000375, 127 North Gross Avenue.
Correct.
And Officer Gasson, present
Briefly,
the company, present the city's position, please.
it's not in compliance, and, we went through the board hearing, board gave that date. It's not in compliance as of March 15th, and basically at this point, it's for the board to have the fine set. It's a little abstract case, so we have to accept the affidavit of non-compliance, and then I guess we're going to need a motion to establish what the daily fine would be moving forward from the non-compliance date. Trust me, this is the only one we're going to do this with. It won't happen
Okay,
again.
you want to remind them what the case was about so that they can understand?
It was an overgrown lot, a dilapidated building, overgrown lot, and that basically is the gist of it. So, and it's still, the building itself is still in very, very poor condition. They've done some cleanup on the property. But because 840 and 852 deal with clearing the lot and debris and the structure, those two ordinances, 840 and 852, are still in place. They still do have some trees on the property that need to be removed under 13302. So in effect, they're in non-compliance for all of those ordinances.
Okay, so we need a voice vote.
Be a motion to accept the affidavit of non-compliance and set the dollar amount of the fine for every day that it exists after March 15th. That's what you're going to need to do on this particular case.
Okay? Can we get a motion?
I have no idea.
Okay, I'll make a motion, I'll give it a shot. I move based on the testimony, evidence, and facts presented in law that the respondents failed to timely comply with this board's prior order within the time prescribed and to award the city $100 for the costs incurred in the prosecuting the case, if there's no date on this.
We need a daily fine from every day after March 15th.
It's 29 days.
Well, it's gonna continue to run until it's brought into compliance.
right now.
Okay,
So,
far it's 20.
so was your motion $100 a day, sir? $100 a day? Okay, until it comes into compliance. Okay.
Okay, good.
Any second?
I'll second.
discussion?
15th.
All right, let's have a vote, a voice vote.
I'm sorry, who was my second?
Do we need a roll call vote or?
Roll call vote.
I'm
There was
sorry,
Ms.
roll call.
Vacacy.
Who was the second?
Ms. Vacacy. So the motion is that you're accepting the affidavit of compliance, finding the property is not in compliance by March 15th, and ordering a fine of $100 a day until the property is brought into compliance. That's the motion. There has been a second. Roll call.
Well, let's have a roll call vote, please.
Mrs. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Mr. Sherry?
Yes.
Mrs. Archer?
Yes.
Ms. Vacacy?
Yeah.
Mr. DeMoss?
Yes.
Thank you. Okay,
Go on to the next one.
all right.
And that one, we can just do the $100 per day on that little blank, correct?
Okay,
The next one's
in
just a
regards
normal
to case,
affidavit of noncompliance. You guys already set the fine. This is an affidavit of noncompliance, or do you accept it? That's what the next case is.
And is there any cost affidavit to
Not,
that?
not at that point. I primarily am going to hold those out until the affidavit of compliance. But this was a situation where I kind of drew my line in the sand of when I was starting the prosecution costs, and this one was prior to that date, so.
Okay, so in the form motion that you have, you can just end it with, after the words "time prescribed," and just leave out the language about awarding the city its costs, and then that would be sufficient. In other words, like we used to do an affidavit of noncompliance. I
Just-
move to accept the city's affidavit of noncompliance.
Okay, I move to accept the city's affidavit of noncompliance in the case of 16-800000604.
Perfect.
Any second?
Second.
Any discussion? All right, let's have a roll call vote, please.
Mrs. Dabbs?
Yes.
Mr. Bergerman?
Yes.
Mr. Sherry?
Yes.
Mrs. Archer?
Yes.
Ms. Vacacy?
Yes.
Mr. DeMoss?
Yes.
Motion carries.
All right, that brings us to affidavits of compliance.
I move to accept the affidavit of compliance in case number 17-800000056.
This is just a voice.
Second.
Okay, can we have a roll call vote, please? All those in favor say aye.
Aye.
Opposed? Okay, passes. All right, that brings us to old business, approval of minutes.
Okay.
December 2016 workshop minutes and the February 2017 and March 2017 hearings. All those in favor of accepting the minutes?
Need a motion first.
Oh, we need a motion. All right, then. Can we get a motion?
Do we have to do them all separately?
No, you can do them together if you want.
I'll make a motion that we approve the minutes as written.
Okay, second?
Second.
All right. All those in favor say aye.
Aye.
Any opposed, say nay. All right. That brings us to public comments. Anyone here making a public comment? Apparently, there's no one in the audience to do that. Board and staff comments.
I just have I have a question.
Yes.
Because of the two resignations and the fact the last two meetings we've had struggle to make quorum, do we have any idea when the city commission is going to be appointing new members?
That's a good-
I,
Go ahead.
Deputy City Clerk will submit it to the board, and they will make the decision after the application's been reviewed. I do not have a time at this time.
Okay, but that's in motion. We do have some perspective.
I just know that it has been presented to the board, they review the applicants, and then they will make a decision.
Any other board comment? I'd like to make a comment to put on the record to thank both Mr. Solisky and Mr. Kramer that were on the board for quite some time and provided excellent service. So I'd like that noted in the record that they both, for reasons known to them, had to resign, but I think that it should be recognized. They served the city well. Mrs. Archer?
I'd like to wish everyone a happy Easter.
Oh, right back
Well,
at
thank you.
back
And
in.
this year, to point out, the Greeks,
Greek Easter
we're
too.
right with you, okay? We're going to be different next year, but this year, we're all together, so. Anyone else? I'd like to just say to you, Mr. Sherry, I stopped you, and I probably did that a little bit too fast, but in my old job of being a hearing officer on the railroad, I had to stop it because it was always on the verge of chaos. And so I apologize to you for trying to stop you. I probably should not have done that. And
No need, but thank you for the apology. It's just it's one of my pet peeves.
all right, well,
Thank you.
I know you feel very strongly, and I would also like to thank everybody on the board for voting me in, and I appreciate that Mrs. Archer's stepping up to take the vice chairmanship, and I know she's gonna do a good job. Anybody else?
Sorry.
One last,
You're never going to
you
be
did a good
absent.
job.
Pardon?
You're never going to be absent.
Now I gotta warn you about that, but I wanted you to be voted in first, so I'll talk to you about that later.
Is there gonna be an inauguration ball?
Well, I'll tell you what, let me talk to my wife.
Everybody's going to their house tonight. Good party.
From code enforcement.
Thank you
I'll
very
try
much.
to make this thing a little bit better
Let the
next
record
month.
indicate that the time is 3:17.
No, it's 4:05.
4:05. I'm looking at a clock that belongs to the city there, Mr. Trask. We've got to get that fixed.
Yeah, I know.
Okay, it's 4:05 and we're in adjournment. Thank you very much.
I want to make sure you get all your hours in, okay?
All right, well,
Yeah, I know.
I bet it went much better. And as we get a little bit more used to the program, it really does.
Drug me a little bit hard lot. We didn't get a chance to kind of review it. We were kind of putting this stuff together.
Yeah, and I need an affidavit of compliance to know when it stops, so I know the time frame these people are looking at. Yes, ma'am? Yeah.
I didn't get a chance to keep it out. I originally was thinking of doing
Aw,
those completely
well, just send it to me.
motion is written.
Yeah, just email it to me, that is fine. I mean, we got a few little
Yeah,
quirky
you don't want to
things.
visit the case 3 times.
Yeah, completely understand, so I'll make sure that that's how we roll them in there.
I have to have it because there's a start and a finish. Because he's telling the board, we're starting to find them after this period of time and this stuff. Well, the affidavit of compliance should be accepted in affidavit of compliance period of time.